On April 22nd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash call and found a vehicle inoperable due to a collision and blocking traffic. Law enforcement officers spoke to a wheel witness who stated he observed the defendant in the driver's seat of the vehicle with the engine on and advised the defendant to turn the vehicle off and exit the scene. The law enforcement officer made contact with the defendant who was sitting in the driver's seat of the vehicle and observed slurred speech, moderate odor of alcoholic beverage, and glossy eyes. The defendant admitted to consuming one alcoholic beverage. SFST standard field sobriety tests were conducted. A 6 out of 6 on the HGN was reported, a 7 out of 8 on the walk and turn, a 2 out of 4 on the one leg stand. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
If I may, Your Honor, what the officers completely failed to leave out of their report is that the car was registered to the other person that was present. The other person had the keys on them. The other person admitted to driving. At the time of the accident, I'm not sure why they switched seats. I don't know. I do know the wheel witness came after the accident had already occurred. They had been waiting on a tow. If the officer would have done any due diligence in his research or questioning, the other person they may have been intoxicated. I'm not sure. He didn't even follow up with them. They openly admitted, this is my car. I'm the one driving. The officer made no attempts to remedy that situation or even mention that in his report.
Do you have any of that?
Your Honor, I would just say that, I mean, based on what we have in the DIMS, a wheel witness put the defendant in the driver's seat of the car.
After the car was already inoperable. He didn't see her. He didn't see the accident.
Your Honor, I would say for probable cause purposes, we have a wheel witness that says they saw the defendant behind the driver's seat.
Of an inoperable car.
And a law
I mean,
enforcement officer saw.
at the scene of the accident, right? I mean, if you have some kind of other evidence to show, I have to give them time also, you know? I mean, this is just,
Yes.
probable cause is a very low.
Notice what just happened. The judge made it crystal clear. Probable cause isn't a conviction. It's simply enough to move the case forward. But if the defense can prove the driver switch, this entire case could fall apart at trial. Crazy how thin that line is.
Right.
Right. So this doesn't mean that you're guilty. I mean, if that's in fact true, that's why we have trials, right? There's always two sides to the story. I wasn't there. You were there. You know what happened. I don't know. So that's something that you bring out in trial and, you know, perhaps even before, if you show it to them and it's in fact true.